Hi, Brenda.
Hello.
Hi, Noah. Can you hear me?
Yes, can you hear me?
Yes, I can.
Great. Okay, I'm gonna close my email, but I think we're all set, so that should be okay.
Me now?
Yes.
Great. Well, good. So we have Darla, Dave, Martha, Noah, oh, and Angela Brothers, and Hattie. Welcome.
Oh, no!
Hello, everyone.
Hello.
Can anyone hear me?
Oh,
Hello. Who all's on here? I'm trying to get signed on from several different ways. Sorry for the glitches.
Oh, I'm on two
ways right now.
Okay,
I'm going to hang up here.
Yeah, we can see you.
Hi, Darla.
Hey, everyone. How many of us are on here?
Hey, Darla.
Hey. Noah, are you on here?
yes, I'm on here. Hello.
Okay. Did I interrupt you presenting? I'm sorry.
No, not at all. I think we're just getting set up.
Darla's prone to do that.
Oh,
Well, we're still waiting. We're still admitting people, so I was just giving it a minute.
okay. Okay, as long as everything's good, I'm going to shut up and let you do it, Brenda. I'll just be here. Thank you, Noah, for doing this.
Yes, thank you.
Who is Angela's iPad? Is that Angela Brothers?
Yes.
Awesome. Thanks. What do you think, Noah? Do you think we should go ahead and get started, or?
Yeah.
Okay. 7, 8, 9, 10, 11, 12. Almost 12 of us here, so I think that might be it for now.
Also
nice. Okay.
So welcome, Noah. Please give us all your information.
Hi. I'm Noah Seidel. I'm from the Office of Developmental Disability Ombuds. So we're doing this over Zoom. So what I'm going to do is share my screen that will have the slides. But I think when I do that, I won't be able to see you all. So if you have questions, feel free just to interrupt me when I'm done with the slide. I think this is something that is new for a lot of us, but probably by the end of the month, we'll be very used to these Zoom type of presentations. If anybody's having issues, also feel free to say something if the audio is not working or the visuals. I was going to show some videos, but I took them out because I don't think it works that well showing videos over Zoom. but I'll send the link. The links are in the end of the presentation that Brenda will send out. So to the videos you can watch later. So I'm gonna start sharing my screen. So do you all just see the opening slide?
Yes.
Great. Okay, and I can
Yes.
see you on one of my other monitors, so this is great. Okay, so the things that we're going to cover today, the main focus is going to be about supported decision making and what that means, what it looks like. But in order to get there, we're going to start by talking about different types of guardianship, and we'll go through the different types of guardianship, what capacity and incapacity is, informed consent, the different types of decision making, so that's the different types of guardianship and alternatives to guardianship. And then we'll talk about the principles of supported decision making, and then areas where support may be needed. And then we'll talk about what the future of supported decision making looks like. Just to start off, this presentation is not legal advice. So I'm going to go over general information about different types of guardianship, what that looks like, how you can get those types of different guardianships over a loved one if you think that is what is needed. But all of the information here is just educational. To go through that process, you'll have to work with somebody who is a lawyer to set up the different types of decision-making supports, and I'll go through that in the different slides. So this is not a substitute for any legal advice by an attorney. If you want legal advice on different guardianship cases that you might be dealing with in your life, I won't be able to answer those questions. I'll refer you to other people who can. So some of the fundamental concepts. So we're going to talk about capacity and incapacity, informed consent, and then healthcare decision making, and then that will go into always listening to the individual choice and people's best interest in mind. So capacity is the legal term for competence. So when you're talking about guardianship, if somebody has capacity, then they have their own guardianship. When somebody is deemed to be incapacity, that means that they no longer have the ability to make decisions for themselves. So if a person lacks capacity, or what we call incapacitated, that means that they are under guardianship or will be directed to have a guardian. So if somebody does something that breaks the law, when they're going under trial, if they're deemed to be not to have capacity, then that will change what the ruling is and what type of decisions the judge makes. So when we're talking about incapacitated person, we're talking about a person who no longer has the ability to make decisions for themselves. Capacity may change over time based on the experience or the situation. A person may be able to make some decisions and not others. A person may make decisions at some times but not at other times. And then that goes into what we call informed consent. So informed consent to medical treatment is fundamental in both ethics and law. Patients have the right to receive information and ask questions about recommended treatments so that they can make well-considered decisions about care. Successful communication in the patient-physician relationship fosters trust and support and shared decision-making. So informed consent talks about when, even if a person has a guardian, they should be making decisions when they can and be having those discussions. So if a person, even if they do have a guardian, you should be discussing with the person to see what they would like in the decision and giving them as much information as possible. And then ability to make informed decisions. In many cases, this authority is sufficient and no guardianship is needed. So if somebody has the ability to make informed consent, so that's once they get all the information that is needed, they're able to make decisions, then a guardianship wouldn't be needed. So in the different types of cases when we'll talk about guardianship, there will be different levels of guardianship based on what the person understands in those type of decisions. So for a person, the person must understand the following to give informed consent. His or her health condition, the proposed treatment, the hoped for results, possible alternative treatments, possible risks and benefits from treatment, and consequences if not treated. So if a person can understand these different concepts, then they can make that informed choice and a guardianship would not be needed. And when we're talking about supported decision-making, we're talking about, can a person get enough support to understand these concepts? So I'll use the example of possible risk and benefits from treatment. So say a person has diabetes and they go grocery shopping on their own. They like to buy candies and chocolates. With their diabetes, do they understand the risks that would happen if they eat the chocolate? So do they understand that, oh, your blood sugar might spike and you might need more insulin? Do they understand those different concepts? And then once we're talking about other medical treatments, do they understand what would happen if they don't follow through? So it's trying to help support people so they can make these types of decisions. And that is connected to individual choice and best interest. So if a person cannot make these informed choices, people should still be thinking about individual choice in their best interest. So the substitute decision maker should identify the preferences and choices of the person. So if you know that the person that you're trying to provide support would like to make this decision, they should get the supports to try to make those types of decisions. So you really want to, if you're looking for a professional guardian or you're going to be a guardian for somebody, it's really to know what their choices would be too, and then helping them with the best interest. And then it says where the preferences and choices can't be determined, the substitute decision maker may make a decision in the best interest of the person. So if it's believed that that person can't make that informed choice, then it's up to the substitute decision maker to make the choice of their best interest. So you would want to make choices that the person would want you to make, but also looking out for their best interest, which sometimes is against what a person might want. So you're trying to balance those two things. Does anybody have any questions so far? Are folks hearing me and being able to see the slides?
No,
Everything's good on my end.
yeah, it sounds good on my end too. But I have a question.
Yes.
If you have a guardianship of someone is it possible to go in the future and not have a guardian of that person, not be a guardian, that person not have a guardianship?
Yes, so I'm going to talk about the different types of guardianship, but if a person can start with, say, like a full guardian, but then they can then choose to have a limited guardian, or now since in Washington State we'll have supported decision makers, there can be people who can ask to switch from a guardian to now a supported decision maker, and then they do that through the court system.
Okay, thank you.
That's a perfect segue to, we're going to talk about the different types of decision making and what the different options are for people, and how people can go through these different types of decision-making support. So we'll talk about guardianship, limited guardianship, special needs trusts, power of attorneys, represented payeeship, vulnerable adult protection orders, and then healthcare decision-making, and then we'll talk about supported decision-making. So these, I kind of started it from what we consider the most restrictive to the least restrictive options available. So like a full guardianship is what people consider the most restrictive type of guardianship, and then supported decision making tends to be a less restrictive alternative. Okay, so what is guardian? What is a guardian? So a guardian is appointed by the court. So if a parent or a family member believes that their loved one should have a guardian, what you would do is there are paperworks in your county, and each county has different courts that they have guardianship hearings. So you would be petitioning the court to appoint a guardian or say that this person needs a guardian. And the person who is being discussed, they would also attend the court hearing. So if they object to having a guardian, they can also let that be known at this time. And a judge determines if they deem that person needs a guardian. So that person would then be deemed to be what they call incapacitated, like we discussed a little bit earlier. The guardian's role is to protect, advocate for the person who is needing support. So if you're a guardian for somebody, your job is to really help protect that person. So if somebody is deemed that they need a guardian, I like to use that term more than incapacitated person. And I know that there's been discussions to change our legal language from, incapacitated to a person who needs guardian or somebody under guardianship. So I know that's something that has been discussed. So if you're that person, you're a guardian for that person, your job is to help advocate for what that person needs. That could be financially, that could be their housing situation. We're going to talk about how that looks financially. So your job is to really protect and advocate. And you want to help that person make decisions. So a good guardian is checking in with the person that they're the guardian for and really trying to help that person exercise their rights and make decisions for them. The guardian is the person providing support. Often a guardian is a family member or a friend of the person needing that support. And sometimes we'll also talk about professional guardians, and I have a slide for that if a professional guardian is needed. A professional guardian would have no relationship with that person outside of that guardianship. And then this is kind of a side note, but professional guardians have to go through a whole process where they go through background checks. Excuse me. They go through background checks, their credit is reviewed, and then they get certified. So I'm going to talk about professional guardians because sometimes that is what the person or the family chooses. And we'll go through what that looks like. And if you're a non-professional guardian, then you're really there to help support a loved one. That's what we see most often, is somebody who it's either their son or daughter or another family member that they're helping support, and always trying to check in with that person so they get the services that they need. So intent of guardianship law. To protect the liberty and autonomy of all people and to enable them to exercise their rights under the law to the maximum extent, consistent with the capacity of each person. So when we're talking about guardianship law, the law wants individuals to have as many rights and decision-making abilities as possible as to what that person's capacity is. So we know that there are individuals with developmental disabilities who need support to advocate for themselves, to get the services that they need. And that's where guardianship can help that person to make sure that they're not being abused or neglected, they're not being taken advantage of financially, but at the same time, when that person can make decisions, giving those people as much autonomy as possible. And there's a tendency to grant full guardianship of people with developmental disabilities based on a lot of preconceived notions and kind of what was done in the past. Things like supported decision making and some other types of guardianship that I'm going to talk about are newer in a sense. Even supported decision making in Washington, it was this legislative session that it fully took effect legally. So I think it is often kind of thought of going straight to full guardianship, and that might be needed for some people, but what we're going to talk about is what are those other options, and always trying to make sure that the person is being listened to. When we're talking about that, liberty and autonomy should be restricted only to the minimum extent necessary to adequately provide for their own health or safety, or to adequately manage their financial affairs. So in the intent of guardianship law, it talks about doing the minimal extent. And I think that's something that is, something to remember when we're talking to other families who might be thinking about guardian, or it might be your own family, but how we can support people, but also make sure that they're safe and healthy and getting the services that they need. And then this is a quote that was also in the legislation. It says, "It shall be the duty of the guardian or limited guardian of the person to care for and maintain the incapacitated person in the setting of least restrictive to the incapacitated person's freedom and appropriate to the incapacitated person's personal care needs. Assert the incapacitated person's rights and best interests, and where appropriate, to see that the incapacitated person receives appropriate training and education, and that the incapacitated person has the opportunity to learn a trade, occupation, and profession." So this is in the intent of the guardianship law in Washington, that if a person has a guardian, this goes to what Darla was asking about, they should still be giving education and training. And I think it is a goal for a lot of people who are under guardianship to one day be their own guardian. And we know that maybe not everybody can get to that goal, but for many people, it's giving them that education and then giving them what they need to best make decisions for themselves. And while they do have guardianship, to still be involved in that process. There are people that I meet when we go visit folks who Some of them have guardians, but still make their day-to-day life choices. There's other folks who don't have guardians, but before they sign any piece of paper or make any decision, they call their parents or their family friend. So I think that's something to always keep in mind, that the law is looking always at that least restrictive alternatives, and to always be helping a person understand what is going on, even if they're not the ones that are making that decision, so they know what is happening in their life. So this slide talks about more of the guardianship process. So a petition is filed. So a lay guardianship is when somebody outside of the family believes that that person needs a guardian. So we call them lay guardians. So that could be if a worker thinks that that person needs a guardian, or some support staff, or family guardians must complete an online training. So a petition is filed that this person should have a guardian. And then the person who might be going under guardianship, they get a notice that their rights are going to be changing. So we see this often for folks who have mental health disabilities. They'll get a notice, or people with developmental disabilities will receive a notice that their rights might be changing. And then a guardian ad litem is appointed, and that could also be considered a visitor. So a guardian ad litem is a person who would go and meet with a person who might be going under guardianship or be seen as incapacitated. They would talk to the individual, get to understand their situation, and then the guardian ad litem would also write up a report that would be used in the guardianship hearing. An attorney may be appointed for the alleged incapacitated person. So we also can call that their, so that is if a person is going to go under guardianship, but they don't want to be under guardianship or be an incapacitated person, they could get an attorney to fight that. And then that language is going to be changed to a respondent. So there's been some work done in Washington. Also under guardian ad litem, we see that it now says visitor. So they're trying to change this language so it's more simple language for people with developmental disabilities and others to understand this process. As I mentioned before, we use some language that is hard to understand for people. So I know a lot of developmental disability advocates have worked with the Office of Public Guardianship, and we had the WINGS program in Washington to try to change this language to make it easier for people to understand. So once the guardian ad litem comes out, they do the visit. If a person is objecting, they could hire an attorney. Then there's going to be a medical physical reports, and then the hearing is held. So then the hearing would have all these reports, and then that would go before the judge. And then if the guardian is appointed, the court issues letters of guardianship. So that is the formal notice to the person that they are under guardianship. And then also it is given to the person who's going to be the guardian. And this is also when alternatives to guardianship can be looked at before the judge. So if the person doesn't want to have a guardian, now is when other types of supported decision-making or other forms of guardianship can be discussed. So this slide is the kind of legal step-by-steps that would happen in that process. Any questions on that part? So I'm going to talk a little bit about the limitations and restrictions placed on the incapacitated person. So this is the person, again, under guardianship. The right to vote may be revoked. Not on all the times, and I have a slide that I'll do that talks about voting in more detail, but your right to vote may be revoked. Right to marry or divorce. So if a person has a guardian and they want to get married, the guardian has to okay that marriage or divorce. So people with developmental disabilities want to get married and they have a guardian, then the guardian also has to be okay with that marriage. The right to make or revoke a will is revoked. So the person no longer has the ability over their will. The right to enter into a contract is revoked. So that could be any type of contract. So it's the guardian's decision to enter that person into contracts. So that could be phone plans, apartments, getting an apartment on a lease. The guardian would oversee that person signing into contracts. And then this goes connected to that, but the right to buy, sell, own, mortgage, or lease property is revoked. The right to possess a license to drive is revoked. The right to consent to or refuse medical treatment. So the guardian is in charge of medical treatment for that person. The right to decide who shall provide care and assistance is revoked. The right to make decisions regarding social aspects of life is revoked. So this is all under full guardianship. So if a person is under full guardianship, these are things that the guardian now determines if the person does this or not.
So, excuse me, can I ask a question?
Yes.
So I missed the one. So the right to vote, can they vote if the guardian deems it okay?
Yes, and I have a slide that is coming up in a few slides that goes into voting.
Okay.
And it's, I'll get there. It'll be in 2 slides, and I'll talk about voting in more details. But yes,
Okay. Thank you.
Under full guardianship, it automatically gets revoked. But then there's ways to have it where that person can still vote if they have full guardianship.
Okay.
Are these limitations and restrictions going to change with the Guardianship Reform Act once that kicks in?
So under full guardianship, this would still be under full guardianship, but we have other options now for people that they can do instead of this full guardianship that will make it so people can get supports in different aspects, but then keep these rights. So some things that doesn't change, so decisions a substitute decision maker can't make, sterilization, antipsychotic medications, restraints, placements against somebody's will, psychosurgery, and shock treatment like ECT treatment. So those are things that a guardian cannot decide under full guardianship. The person can still say that they don't want these things to happen. And then this, I'll talk about voting now, which is, so the judge will determine whether to maintain the rights to vote and make a ruling. So if a person says, you know, I understand that I want a guardian, or the guardian says this person needs a guardian, they can still say, but this person should be able to vote. And then the judge would make the ruling on if that person can vote or not. So you can have a full guardianship, but still ask the judge to keep your voting rights. The guardian does not vote for the person. So if the person can still vote, the guardian does not vote for them. the person would still make the choice who they want to vote for. They can get help on how to vote. We have a lot of different ways for people with developmental disabilities to vote, but they get to make that determination on who they vote for. And then the basis for the right to vote is the person must understand what voting is and must have the ability to make a choice. So that's what the judge is looking at. Do they understand what our voting is, and can they make a choice? And then this is like just kind of a side note, is sometimes when a guardian person gets a guardian at age 18, they might not think or care much about voting, but that can change later on, and they can always go back to the judge and request to be able to vote. I think that's something that we see is that, you know, sometimes it's not something that people are thinking about, especially I'm going to talk about guardianship while people are still in high school and in transition programs. And sometimes voting is not what is on the person or the family's mind at the time, but it's something that might come up later. So that is voting. Did that answer your question? Okay, great. So now I'm going to talk about different types of guardianship that's not the full. So we're talking about limited guardianship, estates, guardianship for minors and people going into 18, and then professional guardians and a few other different types. Okay, so we have limited guardianship. So limited guardian may be a guardian of just the person or just the estate. A limited guardian may have some specificality identified in authority, and then no other authority. So for limited guardianship, you could say that this person needs a guardian for certain parts that we discussed, but not in other parts of full guardianship. So maybe a person is entering into contracts. They're signing up for phone plans. They're signing up for credit cards. Anytime somebody asks for their signature, they give a signature, right? People with developmental disabilities sometimes can be taken advantage of, and you're afraid that that person is going to sign up for something or sign into a contract. So you could do like a limited guardianship of saying this person can no longer sign it into contracts, but they can still vote or do other things. They can still make medical decisions about themselves, but this is what is going to be limited. So a limited guardianship can be over just certain aspects. For this, it's really to decide, maybe there's like one thing in particular that person needs assistance on, but in other aspects of their life, they don't need assistance. So that's where a limited guardianship. And then we're going to talk about other parts of like more financial types of guardians, because that's something that does come up a lot. So the CART can tailor the guardianship to individual needs. And this is favored in public policy. So when we discuss that intent of guardianship law, and it talks about giving people the most freedoms and liberties, this is what they were really imagining, this limited types of guardianship. So you can really tailor it to what your family member or loved one or whoever else, if you're working with somebody else, what they need. And this is what I think happens more often than like a full guardianship nowadays. So guardians have different responsibilities. So develop personal care plans. So the guardians could help if somebody is getting DDA services and they're getting different, they're writing their care assessment or they're getting involved in what services that they are going to be using, the guardian can help have those discussions. It could be preparing reports. So if anybody has to file inventories or tax reports, the guardians would help with those. Guardians attend meetings. So if a person is 18 through 21 and they have a guardian, transition meetings in the high schools. I also see it for folks who are at the state institutions and other folks using DDA services, their IISP meetings, their transition meetings, their care assessments, guardians would be involved. Guardians have to visit the person. So guardians should be visiting people on a monthly basis, checking in, making sure they have what they need. Watching for and response to abuse and neglect. So it's the guardian's responsibility to make sure that the person is not being abused or neglected or being taken advantage of. Promote independence and employment of a person. So guardians also can help people become more independent and give them the skills that they need. Also, if a person is looking for employment and they may need accommodations, guardians can work with job coaches or employers to help that person get set up in their job. Show respect and listen. So this goes back to that informed choice and giving people what they need and really listening to what that individual would want. And then this last one is just be assertive. So guardians have a lot of responsibility if it's through care services, out in the community. So the guardian should really be there to help advocate for that person. I know with the DD Ombuds office, we work with a large amount of guardians who are trying to get services for their loved one. And we are working with family members who are guardians, close friends, other relatives who are, in charge of these persons' services. Some people who live in Washington State, and we've also worked with people who live outside of the state, and that's why they call us, is because they need somebody to attend a meeting or to help advocate for a person, and they're doing it from outside of the state. So now I'm going to talk about a few other different things outside of guardians. And this goes more into like the supported decision making and what other options are available for people. So we, in Washington State, we have special needs trust and we have ABLE saving plans. So these are where guardians and also supported decision making folks can help out. So these are both to protect SSI and SSDI benefits and other needs based on income. So the guardian can help keep track of that. Where I'm also going to talk about representative payees who help manage people's funds. It can to help ensure these accounts are wisely managed. So if a person needs help managing their money, like I know that there are people who they get funds and then they spend all their money in the beginning of the month and they need help pacing their spending. Also to protect from creditors. So if a person, is signing up for phone plans or contracts, payment plans, to make sure that they're not getting in bad credit. Developmental Disability Life Opportunities Trust. So we have the Washington ABLE Saving Plan. So the ABLE accounts in Washington that can be used to put money away, which doesn't affect people. So if there's a cap on how much you can have, put money in your ABLE account, and then you can use that money to buy things. It can help pay for rent or other supplies. And then we also have the Special Needs Trust in Washington State that people can put money into and then use that trust to go on trips and to plan events. So these are ways for people to save money who are on SSI and SSDI so they don't go over their caps. And then we have power of attorneys. So we have a few different types of power of attorneys, financial, medical, and then durable power of attorneys. So a power of attorney, so we have an RCW and authorizes an individual to designate others to advocate on their behalf, including making medical decisions through a power of attorney. So this can be used if somebody needs help making medical choices around medications, surgeries, how to make those type of choices. They can have a power of attorney. So you wouldn't have to go through guardianship. So say a person can do all the things that would get revoked under guardianship, but they need help making medical decisions. They could have a power of attorney. And then there are durable power of attorneys. So these are effective when the person making the power of attorney is incapacitated. So this is a person who can be there if the person making the decision or the person who is the power of attorney can't make that decision, can also have a durable power of attorney who can be ready to help make those decisions. And I can provide this link in Washington Law Help. And this is another alternative to guardianship. So this is for when the person can't make decisions. Maybe a person is healthy, they can make their decisions, but then something happens where now they're in the hospital, they can have a durable power of attorney on standby, ready to make decisions. So some advantages of power of attorney instead of guardianship. So it's easy to create at little or no cost. So you don't have to go through the whole court system to have a power of attorney. This is something that you can just create. Provides an advocate with authority. So if you're afraid that a loved one is not gonna be able to make decisions, this gives another person that authority to help advocate. They can also help set up a guardian if that is need be. There's principles over control of choices. So this person only makes those decisions if the person is incapacitated. So it's not all the time. It's only if it's need be. It can be revocable. And then this person is a fiduciary. So this person can also help make choices that involve money if the person is incapacitated. And then some disadvantages of power of attorney is there's no court oversight. So it is possible that there could be abuse in the system. If a person is incapacitated, the person can make more choices without the court being involved. The authority may be challenged. So if a person comes in and they say, oh, I'm the power of attorney, I want you to do this, this, and this, and it seems kind of unrealistic, that authority can be challenged, and then it does go to the courts. And then must meet capacity requirements. So if the person, there are some people who they're kind of like on that line of having capacity or not capacity. It can be argued when the power of attorney is now making decisions. So I think that's something we see, I would say a little less in the developmental disability community, but maybe sometimes for the elderly population, their capacity starts being challenged. Maybe it's by their kids of a person. And then there's kind of this argument of they're like, well, is this person, are they able to make that informed choice or not? And that's where that authority kind of comes into question.
Noah,
Yes.
on the previous slide, This is Brenda. On the
Yeah.
previous slide, yeah, it says that it can be revocable. Who revokes it? The person or the court? I mean, the court's not involved, so who would revoke it?
The person can revoke it. And that kind of goes similar to like the capacity requirements. The person can change their mind, and then there can be an argument over if they have the ability to change their mind or not.
Yeah.
So it's less permanent. So I think there's some, like, what I've heard is that there's sometimes hesitation over if this authority is going to happen, or there might be like an argument, like say at a hospital, well, I'm the power of attorney, but this person's not listening, and then they're saying that they're still can make that capacity decision. So it's just a little more of that gray area over when it's going to be used.
Okay, thanks.
Yes. And then
And you know what? I had a question too. So with the power of attorney, if you exercise it, but it turns out like my son, for example, thinks he should make that decision, he could say, I've got capacity to make this decision and challenge it. Is that what you're saying?
yes.
Okay.
Yeah, so it's not, because it's only happening, I'm going to go back a little bit. So you're designating somebody, and then if it's like the durable power of attorney, the person has to be seen as incapacitated. So depending on which type of power of attorney you have, it only takes effect in certain situations.
Okay.
So yeah, if like for your son, for example, if he decides I no longer want you as my power of attorney, he can get that revoked. And then he wouldn't have to go through the court process like under guardianship.
Okay. So just like the durable power of attorney, it says affected even when the person making the power of attorney, is it incapacitated or only when the person is incapacitated? Is that even or effective only?
It should say only, sorry about that.
Okay. That makes more sense. Thanks.
Yeah. And then representative payee. So representative payee is when an individual with disabilities receives money or benefits from an agency and is not able to manage his or her own money. A representative payee may be appointed to be responsible for the benefits and to ensure that they are used only for the benefits of the person with the disability. So representative payees, so I see this in a lot of different situations, but commonly people who are using DDA services on the core waiver in supported living, I will meet people who have a representative payee. Sometimes it's a family member or a friend. Some providers also provide representative payee services. So sometimes the provider themselves will also be that person's representative payee. So they're managing their Social Security benefits, other benefits they might get from the state in order to pay their rent, in order to buy supplies. So this is to help manage their money. So there are some people in supported living who will get, their money will go to the representative payee, and then the representative payee will give them maybe $20 a month to go shopping for other things that they want. Or it could be, I really want to buy this new video game, and then the person asking the representative payee if they have enough money to do that. And then the representative payee is making those decisions. So the representative payee is a fiduciary, so they're making those money decisions. They don't have any other control of the person's choices. It's only their money. So this is used for people who can make all, their choices, and then they just need help managing their budgets and using their benefits appropriately. So this is something that I see pretty common out there. And it can be done by, again, family, friends, providers, and then there's also agencies that you can find out through Social Security what agencies are in your community that are represented payees.
So if you have a guardianship, do you also need a representative payee?
You can, if you want somebody else to be your representative payee.
Otherwise, your
Guardians can also just help with the money.
Okay.
I think this is, so under guardianship, the person could still get their money directly to themselves. But a representative payee, like the benefits go directly to that representative payee, and then the money then goes to the person.
Okay.
But you could have a guardian and then still control your own benefits.
Oh, interesting. Okay.
Yeah. And there's a service through Disability Rights Washington that does representative payee monitoring. So if you are using an agency as the representative payee, but they're not providing receipts or tracking the person's money, there are agencies that make sure the representative payee are following what the person wants with their money. So then there are things called vulnerable adult protection orders. And any person can file a voluntary adult protection order petition. So this alleges abuse, abandonment, financial exploitation, or neglect of vulnerable adults. And then also during this legislative session, they also added stalking to the list. So this, the court may take prompt action to stop abuse and prohibit contact. So if a person is being abused, or this would stop that contact. The vulnerable adult who doesn't want this to happen may oppose. So this could be if you feel like there's a person who is abusing somebody or taking advantage of them, this order would help prevent that.
But the person could say they could oppose it even if you have guardianship?
I believe so. So if the person, I mean, it would still go to the court, so then the court would make that decision. But if, like, say a person has a friend who they like to hang out with, they see them at events, somebody else files a VAPO, the person can then also go and oppose that and say, no, this is a friend, this is somebody I want to be with. They're not doing those things. And then the court would make those decisions.
Wow.
And then I put some information about that. Washington Law Help is this second resource, and they have a lot of great information around guardianship, representative payee, everything that we're talking about. They have different information you can find. And talk a little bit about healthcare decisions. So this is if a person doesn't need guardianship, maybe not a power of attorney, but still needs some healthcare help and support. So when an adult cannot give informed consent, they can have a healthcare guardian.
Hello?
The agent with healthcare durable power of attorney. So this could be a husband or wife, a son or daughter over 18. They have to agree. Mother or father, both must agree, or brother or sister. So this is a person who would help make healthcare choices.
So, excuse me, how is a health care decision making different than a medical power of attorney?
So this is something that's new.
Oh, okay.
So this started in 2019 in the legend. So this was just recently taking effect.
Okay.
So this person would be more of a support. So they're not making the choices as much as they're able to help talk to healthcare professionals. So they can help relay information or get information from healthcare professionals, but they're not making those decisions.
So it's kind of helps sometimes with HIPAA, you can't talk to anybody, but this makes it easier to talk.
Yes, yes. So this is expands the methods for executing a healthcare directive to include non-notary public. So this is able to just get information. So it's not making those decisions, but helping get information.
Okay.
So then it also talks about criminal penalties for false declarations. So if somebody is giving bad information or false declaration, it would be a criminal penalty. And this is something that I'm still trying to understand more. So I put the House bill number in it because that would be a good way. We're still figuring out what it's going to look like. So it's through this new House Bill 1175.
So has it taken effect yet, or it's going to?
I think it takes effect next year, but I can find that out.
But we'll hear more about it, it sounds like that.
Yes.
Okay.
Yeah, it just passed this legislative session, so it will take effect in let me see real quick. So it takes effect 7/28. Yeah, so it will take effect later this year.
Okay, thank you.
And it also gives other folks who can consent. So adult grandchildren who are familiar with the patient, adult nieces and nephews who are familiar with the patient, and adult aunts and uncles who are familiar with the patient. And then what it also does, it adds non-relatives who know the person well. So an adult who has exhibited care and concern for the patient, is familiar with the patient's personal values, is reasonably available to make healthcare decisions, and who is not a member of the patient's medical or care team or healthcare team. So you can have people who are family, friends, others who are not relatives can help with these decisions. And I imagine that there'll be some more information coming out about what this is going to look like. But I think it's for people who don't have family members or close family members to help make decisions for them.
Could we expect to see court appointees come through this as well?
Can you say it a little bit louder? Sorry.
Could we expect to see court appointees come through this as well? Because I can imagine there are probably some people who, if they don't have any family members, they might not have any friends or other close people to them that can provide these types of services.
I'm not sure. I would have to read through it to see if they would do that or not. But I can try to get some more information on this bill. Yeah, I was thinking back and forth if I should include that or not, and I almost deleted those slides. But we thought it might be helpful just so people know that it's something coming down.
The idea seems fairly similar to supported decision making, just with a bit more specific as to the parties that can do it.
Yeah, and I think that's what they were trying to intend is to get more help in those decision making than, yeah. So I wanted to talk a little bit about special education students at age 18. I know that's a big topic, and if guardianship is needed or not. So at 18, a student's education rights are transferred from parents to the student. So even if a person's in transition programming, if they're in college, their rights go from the parent to the student at age 18. Students who hold their own education rights can authorize any adult to make educational decisions for the student by using a power of attorney. So a guardianship is not necessarily needed for educational decisions. You could do a power of attorney and still have the parent or other loved one help make those educational choices in that 18 through 21 while the person is still in school. So then to go in some other aspects, where there's a guardian, the guardian will represent the student's educational rights. So if a person does get a guardian, that guardian would represent their educational rights. Students without guardians can be certified as unable to make educational decisions. And if this happens, the school district assigns an educational representative. Certification of a student's inability to make educational decisions can be challenged at any time. So what that says is that the student has a guardian, the guardian makes educational decisions. If they don't have a guardian, the school might give somebody an educational representative to make those decisions, but then the person or the family could also challenge that if they don't think that the school, if they need that educational representative. So I think sometimes people go right to guardianship at 18 because they think that if they don't have a guardian or they're not the guardian for their child, then they can't help with educational choices at that point. But that is not the case. So they can still be involved as long as they become either the educational representative or the power of attorney and education.
Can you do, if you're in the process of doing a guardianship for your 18-year-old and it hasn't gone through yet and they're 18, can you do a power of attorney to cover him for his education and then work in the process towards guardianship?
Yeah, that is, yeah. Because it will be faster to do the power of attorney and help with those educational rights. So that is something you can definitely do.
Okay. How long is the process to get a guardianship? I mean, how many months?
I don't know that answer. It goes to enough time for that guardian ad litem to do the visit and to get the paperwork. So I think it always depends on just how much of that paperwork has already been in the process. Okay. And it can really also based on the county, it will alter how busy that court system is.
Okay. Thank you.
Yes, you're welcome. Yeah. And I typically help people understand the guardianship process. But since our office doesn't do that legal work, we don't help people like find guardians. So it's always us kind of getting people connected to other offices.
Mm.
So professional guardianship. So I talked a little bit about that professional guardians have to be certified. So there's a guardianship board that would certify a professional guardianship, a guardian. There's standards of practice, and then there's, if a person is not meeting those standards of practice, there can be discipline, and then there can be complaints against a professional guardian. So if you don't want to be the guardian for somebody, but that person does need a guardian, they can't have a professional guardian. And there's standardized trainings for all certified professional guardians. And non-professional guardians, so if it's like a family guardian, like you're the guardian for a family member, you must complete an online training, but you wouldn't do that standardized training that the professional guardians would have to go through. So it's different for a family or a lay guardian versus a professional guardian. But if people are having issues with professional guardians, there's ways to make complaints. Like if you don't think that person is doing what is in the best interest of the individual, or visiting that person or advocating for them as they should be. And then there is the Office of Public Guardianship. So this is for people who cannot afford a professional guardian. So professional guardians, you're paying that person to be the guardian. So their mission includes support for supported decision-making options, not just guardianships. That's not changed. Currently, they have a 20 individual limit. So each public guardian has 20 people they're the guardian for. There is a bill that passed that gives some more flexibility for larger caseloads. So right now, there were times where the public guardianship was at its max capacity, but they're trying to make it a little more flexible, because there are people who don't need to have their guardian making decisions as often. So they're trying to make a way for larger caseloads for people who can have that, but not take away from the people who need more contact with their guardians. They can help with alternatives to guardianship, support decision-making, power of attorney, payee, and that's something that will be created. And then they supervise and monitor guardians and other decision makers. The public guardianship cannot petition for guardianship. So they don't petition if they think someone needs a guardian, but they only have, say, support decision making, they wouldn't petition the court for like full guardianship. So this is a public office that provides guardianship. So depending on the family's income, they would qualify for public guardianship. Okay, so those are the different types of guardianship, and now I'm gonna spend the last 45 minutes or so talking about supported decision making. Support with decision making. So supported decision making, so sometimes a person needs support in making decisions, but they have the ability to make the final decision. So less often a person does not have the ability to make a decision and someone else makes the decision. So that's why we can have a substitute decision maker. The substitute decision maker's task is to make a decision consistent with what the person would want if the person was able to make the choice. So the supporting decision maker or the substitute decision maker is really there to help the person understand and then make the choice if the person can't make a choice, but to understand what that person would want and help them to get as close as possible to making that decision. A definition of supported decision-making, a series of relationships, practices, arrangements, and agreements of more or less formality and intensity designed to assist an individual with a disability to make and communicate to others decisions about the individual's life. So it's really building a connection with an individual. It could be a family member or a friend to understand what they want out of their life and the choices that they like, their ethics, their values, and help them make decisions based on what you think that person would want, and help them make choices for themselves. Oftentimes, people with developmental disabilities were told that they can't make choices or they don't know what's best for them. But supported decision making is really trying to help people make those choices for themselves and understand what consequences and options that they have. So the basis for supported decision making is the law presumes all adults have the capacity for decision making, including people with disabilities. It focuses on decision making is a learned skill, and that there are many ways to assist a person with decision making. So we always want to start with that a person has the capacity to make choices, and people have wants, needs, and desires. And then from there to think about how we can assist people to get to where they want to be, and help people to make those types of choices. So what are some of the areas that people may need support? Sorry, I'm just gonna move my screen a little. So day-to-day decisions. So what do you want to do with your day? Do you want to have a job? Do you want to stay home? Do you want to do activities? Do you want to go out to eat? How do you want your day to be structured? It can be managing money. So, we talked about representative payees and guardians, but then there are things where, we all make life choices on how we want to spend our money. We could go to concerts, we could buy video games, you could go to a Seahawks game that might take half of your monthly salary to go to. It's really helping people understand that they have choices on how to manage their money, but then there are also consequences on how you spend and manage your money. So, for me, I know that I might want to splurge and go to, a sporting event, and then I'm not going to go out for dinners the next 2 weeks. I'm going to stay home and cook for myself. It's really understanding how your choices, spending your money, are going to affect your life and your budgets. Healthcare decisions and doctor's appointments. So helping people understand their healthcare choices, their medical information. So, I talked about earlier that candy bar situation, but it's really giving people the information that they need to make healthy choices, but also that dignity of risk. So if somebody, there are people who, drink more alcohol than they should drink on a given night. So do they know what their consequences are if they drink, that second drink or not? Do people know what it's going to be if they don't exercise or go to their physical therapy appointments? Do they know, what are the consequences or benefits of doing different things, and giving people that information and having those conversations. And then abuse and exploitation. When we talked about the voluntary adult protection order, we talked about people being opposed to it. I think that can also be said about abuse and exploitation. I mean, it's not good for people to be abused or exploited, and we always want to look out for that and help people be educated on those issues. But then there are some times where there are areas where it can be more up to that person. So an example I'll give is, say you're out at a restaurant with a friend, and you say, oh, I'm gonna buy everybody milkshakes. You know, that can be seen as exploitation because your friends are having you buy milkshakes. But to the person, it can be, well, last time they did something very nice to me, so me buying this milkshake is kind of like a thank you for, you know, them bringing me something the other day, you know? So it's really that, you know, that line of, is this person being exploited? You know, is somebody tricking them out of their money, or are they making the choice to buy something for somebody? You know, and I think that's where supported decision-making can come into play, where it's helping look out for that person, but also helping them. Does that make sense? And then it's also, this says school is saying so. So if the school is saying that the person needs that educational decision maker, supported decision making can be used to say, you know, no, that person can make the choice for themselves, but we are here to help them understand that. We are here to support them and answer questions. And then supported decision making can also go into conversations around services, where a person is living. Are they making the choices for themselves? So these are just some examples, but I think with supported decision making, it can also be broader than that. It's really helping people stay informed and know what the decisions they're making. So Washington law and supported decision making. This is very exciting. So this supported decision making is recognized in the new Uniform Guardianship Act that was adopted the last legislative session, which was literally ended a few weeks ago. So this will take effect January 1st, 2021. We'll have supported decision making in statute. So in Washington State, we never had it in statute until now. So it wasn't like a legal thing people could do. It was more a informal thing. And at least 8 other states have statutes that implement supported decision making. So advocates supported decision making this last legislative session. I think it had, you know, the Arc of Washington on their smiley face chart had a smiley face for the Uniform Guardianship Act. David Lord for Disability Rights Washington has been working on supported decision making for a very long time. I know self-advocates and parents and others have also supported decision making. So this is a pretty big accomplishment for Washington State that many people work towards. So the definition that's going to be in the law, Senate Bill 5604. Excuse me. Supported decision making means assistance from one or more persons of an individual's choosing in understanding the nature and consequences of potential personal and financial decisions, which enables the individual to make the decision, and in communicating a decision once made if consistent with the individual's wishes. So what this means is that people can talk to others to help make choices, kind of what I was saying in the last slide about the consequences and potentials, but then at the end of it, it's up to the individual making the choices and their wishes. And you know, that's what is always you're trying to strive to under guardianship, but this makes it more formal that the person is making their decisions. And what it means for public guardianship, for the Office of Public Guardianship, supported decision making means support for an individual with diminishes decision making ability in making decisions affecting health or safety or to manage financial affairs. Assistance includes, without limitation, acting as a representative payee, an attorney, in fact, a trustee or public guardian. So this is just, the person might have some needs for help to making decisions, but then it's how they can help support that person in different aspects of their life to make their choices. So what is the role and the principles of supported decision making? The role of the supporter is to assist. It's to help the person understand the full consequences, all the choices, all the person's options, what might happen, what might not happen, but to really just assist in that process. The role of the person supported is to make the decision. So the person you're supporting should be making that decision. There is a relationship of trust between the person supported and the supporter. So with supported decision making, it's going to be building that relationship. It might be a family member or a friend, but somebody that you trust to help you understand all the different choices. And then the goal is to balance protection from abuse and autonomy. So it's that, you want to make sure that people are not getting abused, exploited, but giving them that autonomy to make their own decisions and knowing that gray area, that area of, well, this might happen, this might not happen, but this is your decision, and making sure that that person has that autonomy, but they're protected from abuse. So the highlights of supported decision making: individual with an impairment is provided the supports necessary to make a decision. So that could be in writing, through videos, through conversation, but the person who has the disability or impairment should be given everything that they need to make the decision. And then the trusted individuals, including family members, friends, professionals, will commit to help explain to the person in simple language about possible choices and the impact of those choices. So, like I said a few times, but it's really finding different ways to communicate that so that person can make that choice. A person who needs assistance with decision-making develops a person-centered plan. So a person-centered plan would be a great way to really understand that person's values, that person's wants and needs and desires. Person-centered plans have been used in many different aspects of helping people to have more choice and autonomy. So this is another great way to use those person-centered plans. The person can identify his or her, their strengths and challenges. So they can talk about, well, I can make these decisions on my own very well, but in this case, I have some hard parts. And, that could go back to like what I talked about earlier with those milkshakes. There are people who they always want to be the one that buys people the food at the restaurant, or they always want to buy presents and gifts for people. So they can identify that as, that's a challenge for me. I always sometimes want to be too spendy with my money for my friends, and I need somebody to tell me not to do that. But it also could talk about, your strengths. I'm really good at not buying a video game the first day I wanted. I can wait 2 months until I can buy it at GameStop used, so people can identify their strengths and challenges. The person identifies preferences and choices, and what they want and see respected. So it's really creating those guidelines and those ground rules early on in those relationships. And then the person sets goals that they want to attain and identify steps needed to attaining those goals. So talking about the future, and what they want and what their goals are. And then also like who are the other supporters who can help. So it might be like, I want my friend Bob to be my supporting decision maker, but also my mom and dad are good people and good resources to have too. You know? So to know who else can be support. And then some role of the supporting decision maker supporter. So you're supporting the person's decisions, decision making by one-on-one conversations, laying out the pros and cons. So it could be like a pro and con checklist or like a, you know, Venn diagram of this and that. Demonstration and role playing. So it could be, you know, playing out what it looks like and showing them this, you know, this is what it's going to be. Lots of meetings, lots of conversations. So being prepared to have those conversations, those check-ins, those long meetings if it's a bigger decision. Know how a person makes decisions. For example, wait a few minutes to respond. You know, it's like one thing that I encounter is there are people who I talk to who it takes them a few minutes to make a decision or to respond to a question. So I may go and talk to somebody and I say, oh, how's your day going? And their staff might quickly chime in and say, oh, they're having a bad day because this happened. But the person might not want to tell me that. So it's like waiting for the person to speak for themselves and make decisions. And how you ask those questions. Is it yes or no questions, or should it be open-ended? You know, sometimes if you say to somebody, do you want tacos or do you want spaghetti? The person is gonna say spaghetti because that's what they heard last. So maybe instead you say, you know, here's a picture of your different options on a board, point to the one that you want. That might give them more ability to make a choice without being biased. You know, so I think there's different ways to ask questions and present information. It could be words, it could be videos, it could be charts. You know, however that person learns the best or has the best ability to make choices. And then, you know, to really respect a person's values, preferences and decisions. So if you know that a person has these set values and then somebody else talks to them and they do something completely different, you might know that now's a good time to check in with them because, you know, for the last 5 years, you knew somebody, they were always, you know, Noah was always a vegetarian for like 5 years. And then this one person is constantly saying, we need to go get barbecue. Maybe that's time to ask them questions. But then at the same time, to respect a person's decisions. Maybe after you have that long conversation, they say, you know, it's been a couple years and this new barbecue place, I always go by it and it smells very good. And I've been thinking about it for months. And then my friend invited me to dinner there. So I decided, why not? You know, I can have one meal there and then decide what I want to do in the future. And it's like, okay, well, that was your decision. So, you know, it's respecting their values, but then also if that values change or their preferences change, to also respect that. So supported decision-making will be implemented. So that'll be in 2021. Planning and implementation across the world, hopefully we'll get there. You know, there'll never be a single model on how to be a supported decision maker or that support for that person. It might be drawings, it might be, you know, the list, circle of friends, person-centered planning. It's really to be open to different information. This can be done informal or formal, and now we have that opportunity to be more formalized. we have it, so Texas has been doing it for a couple of years now. I think this slide should say 2021 right there. So 2021 is when it'll take effect in Washington. But Texas is the model that I think many of us were looking at because they've had it for a longer period. And they'll need to be, always need to build in safeguards. So, a person can always change and decide, no, even when I'm making a decision, I need a guardian, or maybe they have a guardian now and they want to have a supported decision maker instead. So people can change, but then there might be things that the system needs to do as these changes happen too.
So Noah, what difference does it make that it's now, or is going to be sanctioned by the government? Why is that important?
So now the Office of Public Guardianship and public guardians can be supported decision makers. So like people who were doing it, it was all informal. It was like somebody who's like, I'm gonna go talk to my supported decision making friend before or family member before I make this choice. But now a person will be able to say, I have a supported decision maker. I don't want to give you an answer right now. I want to talk to them and have them be involved in this conversation. So it could be like somebody who is meeting with about their plans. They'll have that supported decision maker that they can invite to those meetings. That will be more formal. And also for people who don't have family or friends to play that role, to have the Office of Public Guardianship to play that role will be helpful for them.
So that they could, so they might provide a supported decision maker then for somebody.
Yes. Yeah.
Okay.
And so it's also like the courts also will have this as, if somebody does say that they are petitioning for guardian, this will be something that the courts can say, let's try this less restrictive option first, and then if it doesn't work, we could go to guardianship, or let's just see how this works.
I was just about to chime in with that. The formal standing from the courts. I recall reading that in there too. It's going to have like actual legal standing now instead of just being an informal thing.
Yeah, and supported decision making as that less restrictive options, because that's what the courts are always looking to. And then there's concerns about abuse and exploitation by guardians. So there are public guardians who do have large caseloads, and then there has been questions about, are they exploiting the people that they're the guardian for? And then there's been also just these talks of different age waves, like with the baby boomer generation aging, they've have been supporting a lot of their family members. And as more people age, aging care workers and caregivers, how people can get support if the person that they trust the most might not be able to help them anymore, but they still want decision-making support. It'll be in statute, and they'll be coming out with more direction on how to use supported decision-making in the coming months before it takes effect through that Uniform Guardianship Act that passed.
I have a quick question about courts and the less restrictive options. When I was reading all of this stuff, it was always laid out very clearly that it was less restrictive options and just supported decision-making pre-guardianship. And that seemed to be really laid out as a really important fact. And I got this sense that was that language not in there before? Was it just kind of like you went for guardianship, they said, okay, here's guardianship? Or is that just something I missed? I'm new to a lot of this, so I'm still trying to figure these things out.
I think it was more of a societal thing, and that was kind of seen as the option. I think even for kids who were going from age 18, like they were being told, families were being told, oh, you need guardianship in order to have any say in this person's life. So this less restrictive options are kind of now being more discussed and then more formally put into our laws and our statutes.
So it was a thing before where they weren't it wasn't necessarily written in like, hey, you have to do guardianship. It was just, that's just what they were used to doing. So they're just like, okay, let's do guardianship.
Yeah, I think so. And I haven't read too much of the guardianship laws before the like some of these newer laws took effect, because I think I've been more focused on this in the past couple of years when these other less restrictive alternatives were already starting to get placed in there.
Okay.
And then a really good website to learn more about this is the National Resource Center for Support Decision Making. They have some great videos from people who have gone from guardianship to less restrictive alternatives, from family members talking about their, nervousness around guardianship and not having guardianship. So, going both ways. So there are some great videos and resources. I have the link to those videos. And then, looking at other state laws. So Texas is a great state to look at. And then there's going to be some training opportunities that the Office of Public Guardianship, I think, are going to be doing. Also, I know Disability Rights Washington, David Lord does some trainings around guardianship and supported decision making. And I think the Northwest Justice Project, which runs that Washington Law Help, they do information and have trainings around guardianship and supported decision making, which I'll send, I think Brenda will send out these slides because we have these resources that you can also look at for information on these different topics.
Sure, and this might be a good time to say that the Informing Families Building Trust, the educational series happening tomorrow night, that's what it is on, is guardianship as well, and they will be doing it via Zoom.
Oh, great. Yeah, I know on their website they have a lot of great stuff already.
Brenda, what was that? Who's having a guardianship tomorrow night?
Here, I'll write it out so you can see it.
Okay.
Noah, hi, I have a question. So, can you hear me?
Yeah.
Okay, great. So for our guys and gals that already have kind of the traditional guardianship, is there a clear pathway for them if this is something that they're interested in seeking? Do we know if there is a pathway for them to reverse guardianship and go to this?
I think what they would have to do you would go through the courts to petition the courts to get off of being an incapacitated person or off of guardianship, and then ask for a least restrictive environment alternative, and then ask that you want to support a decision maker, and then you could say why you would want that. But to get off of guardianship, you would still have to go through that court process.
Okay, thank you.
Yeah, and I don't know this for sure, but I would imagine that people are going to be making documents about supported decision making and how to request that. If you're on guardianship and also if you're not under guardianship, I think the Washington Law Help, they've been tracking the changes pretty closely, and they've done some webinars throughout the process. So I think they're going to be doing some things too now since it's passed.
So this is a question, I guess, for Brenda or Noah. So we don't have guardianship for our son. He's 28, so we've been doing, I guess, supported decision making, some of the power of attorney things. But is there much training is there training for him anywhere about how to be asked for support for decisions or in any of this? I just kind of thinking that I'm not sure he's had any kind of formal instruction or teaching about this.
So the the National Resource Center for Supported Decision Making, they have videos and information that are tailored towards people with disabilities.
So there might be something there you can look at. Okay.
And then also the Washington Law Help, they have information in, I think it's like semi-plain language, if I can say that, about also like guardianship and decision making.
So who's that? Did you say the last one?
The
Washington Law Help. Okay.
And I think more and more things will be coming out now since supported decision making is formalized in our state. Yeah, there's other presentations and videos you can watch on this National Resource Center. That would be the first place I would go.
Thank you.
Here's the question. I want to get guardianship for my son. He's 17. Now, I also want to get somehow like a guardianship for I want my sister to be guardian of him when I decease. How would you do that? If I become guardian of my son now and then have her become guardian after I pass away?
Yeah, so when you're going through the guardianship process, you can set up a secondary guardian that would then take effect when you unfortunately would pass away. So when you're going through that guardianship process, and that slide I had that had the different steps, so you would go through that process, and then in that process you can also set up a secondary guardian.
Okay. Now, when I become the guardian, can my husband can join and be a guardian also, or is it just one?
You can have multiple. You can have both parents.
Okay. Okay. And then
I was just going to ask, so my family is also experiencing the same thing. We just have co-guardianship between my husband and I, but on the off chance that there's something that comes up and we don't agree, what happens then?
I don't know that answer, unfortunately. I think, I don't know what would happen if the two guardians do not agree on that issue. I think you would most likely have to go through the court system. And
Yeah, I'll jump in here really quick, Noah, if that's okay.
Yeah,
I actually had this come up recently, and I called out to one of our board members who was and is a guardianship and estate planning attorney, and she had said that she did not recommend doing co-guardianship or dual guardianship, even if you are a happy married couple, because if something happens or you don't agree about something, you do have to go through the court system. And whoever's doing, I didn't do that. Whoever's doing the training tomorrow night for the Go Wise, the presenter, I know the one last year as well suggested that.
Yeah. Yeah, and I think, that's why most people, I think, tend to have only one person as the guardian, but you'd have to go through that court system, like Kathy said.
Noah, can you put up your contact information up again?
Yeah, what screen
Please.
do you all see? My computer changed all of a sudden without me touching anything. Are you seeing me scrolling through slides?
Yeah.
Yes.
Okay. Okay, for some reason it all went out, but I'm just gonna quickly go through them again. Scroll. So that is the end of what I had.
Wow, we appreciate you doing this. It sounds like you are not feeling that great either, so I'm glad that you didn't have to do the
Yeah,
drive.
my cough just started today a little bit, and I think talking for almost 2 hours straight also probably didn't help it.
Yeah.
But after today, I think I'm working from home for a while.
Good for you. So I put the link up for the training tomorrow night rather than the flyer. I'm hoping that that will do. So you can prepare to watch another webinar tomorrow. I was wondering exactly who the presenter is, but I don't have that answer right this minute. I don't know if it's somebody else does.
Brenda, I think it's the Lori, the attorney.
Oh,
And then for the family stuff, I'm going to be there. And if you want to hop on and help share, that would be great too. The family piece is just kind of what it's like to have guardianship or go through that process. And the attorney piece is the process of getting it.
And that will be on Zoom.
Yes.
And I wanted to say thank you, Noah, for kind of demystified it for me. I thought it was way more complicated supported decision making, but I appreciate
Thank you. Yeah.
your time and presentation.
Thank you, everyone. Thank you, Noah.
Yeah, thank you for having
Indeed,
me.
thank you.
yeah.
Yes.
Martha, I was going to say, I think I started this idea after your suggestion, so I'm so glad you were here.
Good. I'm glad you did it. Thank you, Brenda, too.
Yes, thank you, Noah, and thank you, Brenda and Darla, for putting this together.
Thank you.
Of course. Well, be well and wash your hands.
Oh, okay. Will do.
I just
Take care.
wanted to say thank you very much.
Bye.
I try not to interrupt all of you guys during
Oh,
the talk.
Oh yeah, thank you. Thank you for being on.
Thank you, guys. Stay safe.
Yeah, have a good night, everybody.
Take care. Bye-bye.
Bye-bye.
Good night, everybody.
Bye.